This is UC Davis Live. I'm Satirius Johnson. A leaked draft suggests that the Supreme Court could overturn longstanding protections of abortion rights. What's the reasoning behind such a decision, and what do legal scholars make of it? How did we get to this point, and what are the implications for the other Supreme Court decisions that also deal with the same reasoning? Joining me to discuss these and other questions are two experts from the UC Davis School of Law. Lisa Ikemoto is a Martin Luther King Jr. Professor of Law at UC Davis. She teaches bioethics, healthcare law, public health law, reproductive rights law and policy, and marital property. Her research areas include reproductive rights and justice. And Courtney Jocelyn also is a Martin Luther King Jr. Professor of Law at UC Davis. She teaches in the areas of constitutional law, employment discrimination, family law and sexual orientation, and gender identity and the law. Jocelyn is a leading expert in the areas of family and relationship recognition with a particular focus on same-sex and unmarried couples. Welcome to you both.
Glad to be here.
Thanks so much for having us.
As a reminder, if you are watching us live, we are taking your questions. Just leave them in the comment section and we'll work in as many as we can. So Lisa, let's start with you. The two major cases this current Supreme Court decision hinges on are Roe v. Wade and Planned Parenthood v. Casey. So what rights do Roe and Casey establish? I mean, Roe came first, right?
Right. So Roe was decided in 1973, as many people know. So in that decision, the Supreme Court, for the first time of many, many times, dozens over the years, recognized that under the right of privacy, a woman has a right to decide whether or not to terminate a pregnancy. And it set up a high constitutional standard for testing any state law that sought to restrict access to abortion or the exercise of those rights. And the court revisited that decision again in 1992 in the Casey decision, as you mentioned. And in the Casey decision, the court reaffirmed the right to decide and reaffirmed the core principles of Roe versus Wade. It did a slight readjustment of the test that's used. And the key point for state laws became what's called viability. And so what the court clearly said in both decisions actually is that after a pregnancy is deemed to be viable, states can impose serious restrictions, including bans, except when necessary, except when an abortion is necessary to protect the life or health of the mother, of the woman. And that restrictions before viability, state laws imposed by way of restrictions before viability, might be constitutional, but they'd be subject to scrutiny. So they have to be evaluated by courts to determine whether or not they're valid.
Right. And just remind us, because we'll be talking about it a little later, what was the core reasoning behind the original Roe v. Wade decision? I mean, it was based on this idea of the right to privacy, right? Right,
the right to privacy. So it comes from the 14th Amendment, the Due Process Clause of the 14th Amendment. And as the court says over and over in the leaked draft opinion, the Constitution doesn't contain the phrase right of privacy. And yet the court in a whole set of decisions has recognized a series of rights which are now called substantive due process, including the right to marry, for example, and certain parentage rights. Those are all recognized as sort of this core set of rights that are about very important decisions that we make as individuals. So they help define what we think of as privacy. And certainly as part of what we think of more broadly as liberty, individual liberty. Mm-hmm. So the court recognized the right to decide as being part of that important set of rights in 1973. Then, as I said, set up a constitutional test for it.
Right. And then Casey came along, but also reaffirmed that right to privacy, even though it made some other changes. Right?
Exactly. And in dozens of cases since 1973, the court has reaffirmed that principle.
Okay. So Courtney, let's talk about the case before the Supreme Court right now that might lead to Roe being overturned. What is the case and what is the majority's draft opinion?
Yeah, great. So the case that is pending before the Supreme Court is called Dobbs versus Jackson Women's Health Organization, and it involves a challenge to a Mississippi law that bans most abortions after 15 weeks of pregnancy, which is actually 13 weeks really after conception. And under the Casey decision that Lisa just described, it is absolutely clear that that law violates Casey. Casey does not allow states to ban abortion prior to viability. And so there was a challenge that was immediately brought to this Mississippi law. But in the draft opinion that was leaked, the court very clearly overrules Roe and Casey. And if it were to remain, right now, of course, it's only a draft opinion. This is not the final decision. But if it did remain, it firmly declares, again, that Roe and Casey are overruled. To use the language from the draft, we hold that Roe and Casey must be overruled. And I guess what I'll say is that I think many court watchers are not surprised or will not be surprised if in the end the court does uphold this Mississippi ban, despite the fact that it's inconsistent with the Casey rule. But I think many people are nonetheless surprised by the stridentness of the draft opinion. It really does not hold back. So it doesn't just overrule Roe and Casey, it really mocks those decisions. So the draft opinion reads, Roe was egregiously wrong from the start. It continues, its reasoning was exceptionally weak, and the decision has had damaging consequences. It has inflamed debate and deepened division. And I think, to use the words of another commentator, it's really a maximalist decision. And I think this is part of what has some advocates and scholars worried about other decisions and rights that might be up next on the chopping block.
Right. We're going to talk about those in a minute, but can we talk a little bit about what is the legal reasoning behind the justices, the majority so far on this draft? What is the reasoning behind overturning the Roe v. Wade case?
Yeah. Well, I think, the draft opinion offers a number of explanations for its conclusion that Roe was egregiously wrong. One of the things the opinion says is that the word abortion does not appear in the Constitution. And the opinion also says not only that, but the right to abortion is not one, the opinion says, that was recognized at the common law or recognized in the laws of the United States. And for those reasons, the opinion suggests that Roe was incorrect in concluding that the right to abortion is protected under the Due Process Clause of the 14th Amendment.
Even though there have been cases over the past 50 years saying that there was a right to privacy and there was a right to choose.
Yes. And to be clear, just to add to what Lisa said earlier, it's true actually that the word abortion does not appear in the Constitution, nor does the word privacy appear in the Constitution, but there is a relevant word in the Constitution. That word is the word liberty. And what the court has said is that that word in the Constitution protects a series of important decisions that impact a person's life and a person's destiny. And I guess I'll add here too that it's not unusual that the words in the Constitution require some elaboration by the Supreme Court. That's true of almost all of the words in the Constitution because the Constitution is very, very short. And so it's true even for rights that are more clearly articulated in the Constitution, like the right to free speech. There too, in order to understand what that right means, what speech is protected, when the government can interfere with someone's speech, it requires elaboration by court decision. And as your question suggested, we now have almost 50 years of court decision and elaboration telling us that that word liberty in the Constitution protects a woman's right to terminate a pregnancy.
Does it come down to like a judicial philosophy? It almost sounds like it's coming down to a judicial philosophy whereby you either take the strict letter of the Constitution or you allow for it being a living document in a society that changes over hundreds of years, that you need to be able to interpret it and put it into the societal context, modern context.
Yeah, I mean, so certainly I think everyone agrees that the words of the Constitution are the starting place for any constitutional question. I think all the members of the court would agree with that principle. You start with the words. But as I suggested, the words often are not self-explanatory. Typically, again, because it's such a short document, in order to understand what those words mean, we often require the court to provide elaboration. There are some people who subscribe to a philosophy or an approach called originalism. There are lots of variations of originalism, but essentially they take the position that when the court is elaborating on the meaning of words in the Constitution, they're limited in what they can look at. And specifically, they're limited to the understanding of those words at the time the relevant provision of the Constitution was ratified or practices around that time. Many proponents of originalism argue that that approach is the most objective approach, that we know what we have to look to, what we can turn to interpret the words. I think many others push back on this approach to interpreting the Constitution, I think for a number of different reasons. Here, when we're talking about the protections that the Constitution extends to women in particular, I think some would say that it seems odd for us to be limited to the understanding or practices with regard to the treatment of women at a time in history when women could not vote, a time in history when women could not serve on juries, a time when married women often did not have the right to own or control their own earnings. And so, again, one response to this approach is to say that it's not a correct approach because it cements discrimination and bias into our current understanding of the Constitution. And then I'll add one other thing too, which is, I said that many proponents of originalism suggest that it's a more objective approach to constitutional interpretation, and it guards against judges or justices infusing their own ideologies into our understanding of the Constitution. But I'll add here that my colleague Erin Tang has really persuasively disputed this historical account that is in the draft opinion, this purportedly objective historical account about the historic treatment of abortion. So he argues that contrary to the description of the law in the draft opinion, that actually a majority of states at the time of the ratification of the 14th Amendment did allow women to obtain abortions pre-quickening. And so I think, here, as in other cases, this purportedly objective approach may be less objective than it first seems.
Right. Just want to remind people watching us live, we are taking your questions. If you'd like to leave one, just leave one in the comment section and we'll work in as many as we can. Lisa, let's talk about some practical issues here now with this, this draft. If this draft decision were to become law, what effect would there be on abortion in California?
So in California, there won't be a direct impact in California. It'll be largely indirect. California's own constitution. So let me back up just a little bit. So if there are a conservative majority that seems to be supporting the draft opinion that was written in February holds, then it's up to the states to decide to what extent and whether or not to regulate access to abortion and use of abortion services. So that means that it could be different in every state. And certainly 13 states have already set up so-called trigger laws. So abortion will be banned in those states. California has taken a completely different path. So California's own constitution contains an express right of privacy. So those words are actually in our constitution. And the California Supreme Court has consistently interpreted those words to include the right to decide whether or not to terminate a pregnancy. In addition to that, the state legislature has enacted a number of laws that enable access and elaborate upon that particular right. And it seems like both the administration and the current legislature are working hard to expand on those access to those services as well. So in California, the right of privacy will remain. Access to privacy will remain. It doesn't mean that absolutely everybody will have access because there are still practical limitations, but we'll have the right under the state constitution and certainly the support of the state legislature and the laws that have been passed so far.
Right. And so basically this is a state by state. If this draft decision is actually, becomes the final decision, it really then goes to the states, and there are states that already have these, as you say, these trigger laws that will just automatically go into effect that could place any sort of ban on abortion.
Yeah, and a number of other states, more than a dozen, have already indicated that they would pass bans as well, even though they don't have trigger laws already set up. So it might be that within a year after the Supreme Court's decision is issued, that maybe more than half the states, up to 30 states, will have bans on abortion in place.
And
Carlos,
can I add just one thing in terms of the impact here in California? So Lisa's absolutely right. Our laws will not be affected. There will still be access to abortion here in California, but we will feel the effects because, as Lisa just said, we already have many states that have bans in place to go into effect once Roe is overruled. And what that means is that the states that are still providing access to abortion are going to have many more people coming here from other states. And so there's going to be a lot of pressure on providers here in California. And that might mean that there are longer wait times and more difficulty in getting abortion care here in California.
Yeah, the flow from other states has already begun.
Interesting. Wow. And so I would imagine that this is going to put pressure on funding and, yeah. So Carlos, who's watching on Facebook, asks, can you speak to the reference in the draft to preventing, quote, abortion from becoming a tool of modern day eugenics?
Oh, yeah. So it's a interesting line. In part, I think it tips its hat to an opinion that Justice Thomas wrote in an earlier decision made a few years ago in a case called Box. So in the Box case, the Supreme Court addressed a challenge to a law in Indiana. The Indiana state legislature enacted restrictions on abortion for certain purposes. And Thomas wrote about the use of abortion as an act of eugenics. So he situates it in terms of the early 20th century, how abortion has been used. And the sort of Alito's draft opinion sort of picks up on that thread and talks about Margaret Sanger. And it's abortion may have been used, and Margaret Sanger may have been a supporter of eugenics in the early 20th century. But it's also true that marriage laws and immigration laws were also used in the name of eugenics during that same period of time. So it picks up a narrative that's being used by opponents of abortion that have been aimed primarily at communities of color. So billboards going up in Oakland, for example, hoping for an audience in the Black community there, saying that abortion is an effort to wipe out Black communities. And the Alito opinion picks that up and runs with it. And it's a narrative that's being used by opponents. It's not necessarily grounded in either sort of historical fact or actual experience.
And maybe I'll just add one final thought to what Lisa just said, which is that actually what's really important to understand is that if and when Roe and Casey are overruled, the people who are going to feel the effects of that decision most profoundly are poor people and people of color, people who don't have the resources to pick up and go to California in order to access an abortion, and who, as a result, are going to be more likely to have to continue a pregnancy that for whatever reason they don't want to. And to be clear to what that means, not only does it mean they're being forced to carry a pregnancy, it means that they are being required to undergo a much, much more dangerous and risky health consequence. Childbirth is 14 times more dangerous than a safe abortion. And so these women are going to be forced to endure a lot of health risks to themselves, possibly with long-term consequences as a result of the overruling of Roe and Casey.
Right, and so, some of these state, bans on abortion, I believe they don't have any exceptions, whether for rape or for the health of the mother or anything like that.
Several of the states that are sort of ready to implement bans are the states with the highest rates of maternal mortality, and so it's very likely that maternal mortality rates will go up in those cases. Miscarriage rates will go up. in those states. Those are also states that those rates occur in those states because they have the least sort of access to healthcare for low-income people. And as Courtney said, it hits people of color the hardest because they're disproportionately poor because of the effects of racism in our healthcare systems.
Wendy, who's watching on YouTube, asks, how will the potential overturning of Roe v. Wade impact access to IVF and to surrogacy?
That's a really good question. It's the sort of Supreme Court's decision by itself won't impact IVF or anything like surrogacy. But some of the states may follow up. They'll then have, in a sense, sort of the door has been open for states to regulate pregnancy in other ways. So there's already one bill proposed to criminalize any kind of act. Or I guess it's a law that says, that declares that embryos basically are people, humans, under the law, under state law in particular, which means that an act which destroys an embryo or a fetus could be considered a homicide. So the in vitro fertilization process typically requires that the embryos be screened for chromosomal anomalies and other problems before they're selected for transfer back to the person who's going to carry the pregnancy. And that means that some of the embryos are screened out and they're not transferred, and they're discarded because they can't be used. Sometimes they're donated for research if that's what the people want. But that means that those practices wouldn't be permissible in a state that declared, for example, an embryo to be a person under the law.
I think I read that some of the states were considering, writing up or adding into the law, their anti-abortion law, that their residents would be banned from traveling to other states to have an abortion. Is that something that's even, constitutional?
Courtney, do you know?
So I think we probably will see attempts like that, either to criminalize the act of a person traveling outside of a state to obtain an abortion in a state in which it is illegal, or to do other things to try to impede people's ability to travel to other states to access abortions. For example, a state could also try to criminalize the provision of care by an abortion care provider to someone who is a resident from another state in which it is not legal to obtain an abortion. There are going to be all kinds of questions that courts are going to have to grapple with. So for individuals, would such a law unconstitutionally interfere with their right to travel, unconstitutionally interfere with their right to obtain a protected privilege and immunity of state citizenship? Does it impermissibly interfere with interstate commerce by impeding those access to a provision of healthcare that someone is paying for? So there are going to be all kinds of interesting questions that we we'll have to wait to see what the courts say about it.
It really opens up a whole can of worms.
Yeah.
Yeah. There's this idea in, the legal world that, and I can't remember the Latin term for it, but basically that, you just let previous decisions stand, right? So this flies in the face of that. So where's the justification that the majority justices are using to basically throw that idea out the window?
Yeah, so the concept is called, you're talking about stare decisis?
Right, that's it.
Yeah, the idea that we follow principle. The court starts, and during the arguments in the late fall of this case, there were a lot of questions about stare decisis and the standard that allows the court to, in a sense, set aside that rule of precedent, stare decisis. And the court recited, I remember Kavanaugh in the argument sort of going into a recitation and a brief of each and every case in which the Supreme Court has overruled a previous case, so overruled precedent. You see something like that in the draft opinion as well. And they start with Plessy versus Ferguson, which was the Supreme Court's own decision, which determined that a separate but equal provision in law, and it was at that time it was a Louisiana statute which maintained segregation on railway cars. And the court upheld that as saying that separate but equal doesn't violate the 14th Amendment. And that was overruled finally in Brown versus Board of Education. So the court uses Plessy as sort of its key example why overruling Roe versus Wade and Casey are appropriate, but they're very, very different cases. In Plessy versus Ferguson, when that was overruled by the Supreme Court in Brown versus Board of Education, the court was restoring a right that had been taken away or subtracted under the 14th Amendment's Equal Protection Clause. In the Roe and Casey decision, if they get overruled, the court is subtracting a right that has been in place for decades.
So Megan, who's watching on YouTube, asks, what about the separation of church and state and religious liberty? Judaism, for instance, for some, life begins at birth. What is your knowledge of how religious beliefs affect the potential overturning of Roe v. Wade?
I think that's a political discussion. To some extent, I guess there are certainly, you can sort of look at this sort of recognition by the Supreme Court that the state's interest in protecting fetal life is so important that a state should have the authority to ban abortion completely, as coming from a religious viewpoint and sort of prioritizing one religious view on that over others. And certainly from a First Amendment analysis, you could construct an argument that that's in violation of the Establishment Clause. But it's also, I think it's sort of part of a larger discussion about sort of the expansion of free exercise and the narrowing of the Establishment Clause in First Amendment jurisprudence that has been taking place sort of alongside the efforts to erode the right to decide.
Klaus, who's watching on Facebook, asks, I would like to have clarification of the term, quote, ban of abortion. Can you give us a nationwide overview of ban at any time under any circumstances versus bans after a certain time period of pregnancy? Does Roe v. Wade refer to any ban or only specific bans which consideration of viability or reason for pregnancy?
I mean, I'm happy to. So in Roe, the court set forth a trimester framework. And what the court said there was in the third trimester of pregnancy, the state could ban abortion altogether, except when abortion was necessary to save the life or health of the pregnant person. As Lisa said, Casey altered the framework a little bit, got rid of the trimesters, although reaffirmed the notion that viability was the key line, and so continued to take the position that after viability, a state could continue to ban all abortions except for those necessary to protect the life or health of the pregnant person. But prior to viability, under Casey, a state could not ban abortion, although it could impose certain restrictions on abortion so long as those restrictions did not erect what the court called an undue burden, did not place a substantial obstacle in the path of the person seeking an abortion. Again, the Mississippi law that's being challenged was a ban, taking the position that people could not obtain abortions except in very, very narrow circumstances after the 15th week of pregnancy, that is unconstitutional under the rule established in Casey. If the court overrules Roe and Casey, which is what the draft opinion says it will do, it seems like the result will be that states can ban abortions altogether from the moment of conception. It's possible that subsequent litigation will establish that there must at least be an exception for the life or health of the mother, but that is not included actually in the draft opinion in Dobbs.
What's the argument for having these rights established by courts rather than by legislatures?
I mean, the notion of substantive due process, these important liberties that the Constitution protects, is the idea that these are such important decisions. They're decisions that so profoundly affect a person's life, their life course, that they should not be left to the whims of the voters to determine. And I think, especially when we think about this issue and other issues, it's often the case that when we're talking about these important liberty interests, we're talking about rules that don't apply equally, at least in practice, to all people. They typically apply primarily to groups that have experienced historic discrimination. And so particularly when we see that overlap, the interference with something that is so profoundly important to someone's life, and when it's being applied disproportionately to groups that have experienced historic discrimination, again, it bolsters the notion that these are issues that should not be left up to the political processes and should be ones that should be entitled to greater protection through the judicial process.
Mm-hmm. So, if this draft decision stands, basically throwing out the due process argument, protecting the right to choose, what implications might this have for the future of other major due process decisions, like the one establishing the right of same-sex couples to marry, or the one making laws against same-sex sexual activity, banning that, or the one establishing the basis of the right to access and use contraception? Those are all based on basically the same principle as Roe v. Wade. So what does this mean for these other decisions?
Yeah, such an important question, and one that many people are talking about today. So there are places in the draft opinion where Justice Alito claims that the opinion is limited to the specific issue of abortion and will not have implications for these other liberty interests that you just described: marriage for same-sex couples, sexual intimacy for same-sex couples, parenting rights. So he says, for example, what sharply distinguishes the abortion right from the rights recognized in the cases on which Roe and Casey rely is something that both decisions acknowledge, and here I'm quoting, abortion destroys what those decisions call potential life. And so again, by this language, he's at least momentarily claiming that this decision in Dobbs will not undermine those other due process decisions. But I think many people feel not satisfied and deeply concerned about the future of those other due process rights, in part because there's lots of other language in this very long opinion that seems to apply quite directly to those other decisions. So as I said, he opens by saying what was wrong in Roe was that the word abortion does not appear in the Constitution, and that he claims anyway, that neither American law nor common law had ever recognized such a right. And if that's the basis of the decision, which makes up the bulk of the opinion, that applies equally to the other liberties that we were just describing. Same-sex marriage does not appear in the Constitution. It is not a right that was recognized at the common law or throughout most of this country's history. And so I think for many people, there's deep concern that in the future, this rationale and reasoning will be applied equally and will undermine and possibly result in the overruling of those other decisions. And I'll add one thing too. So you mentioned contraception, which is another liberty interest that has been protected under the Due Process Clause. And that one seems particularly vulnerable in light of this opinion, because that one, he claims to carve out abortion by saying it's different than these other liberty interests, because abortion, he says, is the only one that results in the destruction of potential life. But there are some people, and there's even language that Alito has used in other opinions, taking the view that contraception, or at least some forms of contraception, also result in the destruction of potential life. So there was a decision in 2014 called Hobby Lobby, where a corporation was objecting to being required to provide health insurance coverage to their employees that covered contraception, and they were opposed to providing contraception because in their view, the forms of contraception they were required to provide were abortifacients, to use their word. And Justice Alito also used that word in his opinion, agreeing with their position. So I think the contraception decision is particularly vulnerable in light of this Dobbs opinion.
So what are we talking about? Oh, go ahead, please.
I was just going to add to that. I just want to make sure that those were beliefs that were discussed in Hobby Lobby. It's not accurate.
Right.
So the forms of contraception that were at issue in Hobby Lobby, and they're also subject to a bill that's already been proposed in anticipation of the decision in the Dobbs case, I believe by the Mississippi legislature, also targeting the same forms of contraception. They shut down the ovaries. That's all they do. They act like other contraceptives do. They don't interfere with the fertilization or implantation process that would result in a pregnancy. So I just want to make sure that particular fact was clear.
Okay, but do you see the potential for legislation basically, banning access to contraception that could go from state to state?
Yes. Yeah. Based on these sort of beliefs and claims. As Courtney said, I think Alito kind of keeps moving the target, even within that sort of one opinion about how you distinguish, because the question kept coming up during arguments, right? If you overrule Roe, what about everything else in substantive due process? And so they had to find a way to say that Roe is different from all the other decisions that recognize very important liberty interests and rights. And at one point he says the difference is X, but at other points he consistently says that word's not in the Constitution, but neither is marriage and neither is parenthood. And he talks about how, as Courtney said, inaccurately describes abortion as always having been regulated. Well, so has marriage. Marriage has always been regulated. And it's been banned for many people in the United States through the course of history.
Mm-hmm. Tiana, who's watching on Facebook, asks, so to clarify, this draft does not even prioritize the life of the mother. If a mother was forced to go through with a pregnancy that would result in her severe illness or death, then how can they argue pro-life? Doesn't that ruin the basis of their argument?
There is remarkably little discussion of the pregnant person in this opinion at all. So the opinion does not reserve an exception when the life of the pregnant person is at risk. It seems to allow the state to ban abortion in all circumstances. I suspect there will be subsequent litigation. But again, women do not appear in this opinion. Concern for their health or safety is really omitted from this discussion, as is not only the health and safety risks of the pregnancy itself, but the potential broader economic consequences of eliminating the right to make decisions about whether to continue a pregnancy. And what we know over time is that being able to make decisions about whether and when to get pregnant and to carry a pregnancy to term have enormous financial consequences for women. This eliminating the right to abortion in many parts of the country will have devastating economic consequences on women.
Yeah. Courtney's point, it's actually literal. The word woman hardly appears in this opinion.
Mm-hmm, mm-hmm. A person who goes by the name We Need Critical Thinking, watching on YouTube, asks, can federal law be passed so that the morning after pill is made available and inexpensive in every state? Is it part of commerce, maybe by executive order?
That's a great idea.
So it is possible, right? It's possible.
Yeah, or extend Medicaid and Medicare coverage, right? Could have a federal benefit mandate as added to the ACA to include coverage for those services.
I mean, speaking of executive order, could there be an executive order to make abortion legal across the country?
So, I mean, there are a number of proposals that are being floated. There is a bill pending in Congress. There actually was a vote yesterday that failed in the Senate. That bill, the Women's Protection, Health Protection Act, would codify Roe and would provide that certain forms of restrictions on abortion are impermissible. But again, it failed yesterday in the Senate by a vote of 49 to 51, and it's not quite as close as it sounds because they actually need 60 votes because of the filibuster rule. So I think it's, most people think it's very unlikely to pass that or any other abortion-related law through Congress. There are some proposals that have been floated that the Biden administration could do without congressional action. One thing that has been floated relates to medication abortions, which amount to the majority of abortions in the United States today, a combination of pills that people take. These pills have been approved by the Federal Drug Administration, the FDA, and more recent FDA regulations enable patients to get these prescriptions by telehealth appointments, so making it much easier for people to get access to these pills. Some states have passed laws already that are inconsistent with these regulations, and some have urged the Biden administration to take steps against these states that are passing laws that are inconsistent with the federal regulations. But we don't know yet whether or not any action will be taken. Another proposal that has been floated has been for the federal government to lease federal land to abortion providers. Because even if the land was in a state that banned abortion, the land would be governed by federal law rather than state law. But there too, we have not yet seen any action by the federal government.
Right. Pamela, who's watching on Facebook, asks, I don't know if you have the list in front of you, but asks, without Roe v. Wade, which states could eliminate abortion access?
I don't have a list in front of me, but sort of all of it, probably all the states in which we've already had cases. So Missouri, Mississippi, Indiana. If you look at, there have been publication of a lot of the maps of what the state would look like. So these sort of colored maps of where abortion rights are protected, where abortion rights might be eliminated. And they tend to run the Midwest and the South. So a band of states through there. So states where they don't currently have strong state constitutional protection or existing state laws to protect those rights, and certainly where they have the political will to eliminate the right.
Mm-hmm, mm-hmm. Hard to keep up with, though. The map keeps changing day to day.
Yeah. I know we touched on surrogacy and IVF, but could the decision, if it stands, if the draft stands, enable states to regulate reproductive health decisions other than pregnancy?
Yeah, I think that's a very serious concern. Part of what we've seen sort of hints of this already. It's sort of the rise of this notion of fetal life or the unborn child as something that the state needs to protect. And so if Roe and Casey go down, it gives sort of the thumbs up to the states who would sort of use that sort of as a basis for enacting regulations of women during pregnancy, both criminal and civil laws. So prosecution of women who've had a miscarriage, where the miscarriage is attributed to some sort of wrongdoing or stillbirth, for example. So there's been a decades-long pattern of prosecution of women for drug use during pregnancy, even where a live birth resulted. So they're charged with exposing their children to drugs. There have been prosecutions of women who've gone through miscarriages because the miscarriage was attributed to something they did or failed to do. So I think people who are pregnant are going to be subject to both more, I think, social surveillance, but also in some states, legal surveillance as well. And I think that's a real concern.
Mm-hmm. So, before we wrap up, a final decision from the court is expected by late June or early July. Any final thoughts before we go?
Vote, support voting rights. When you vote, vote all the way down the ticket. because who the DA is, the local DA, will matter for the reasons that I just talked about.
And a lot of these decisions will end up in the state legislatures as well, right? So,
Exactly.
right. And
Yeah.
Courtney?
Yeah, well, I mean, certainly there's so many unanswered questions, lots of important ones that were touched on here, but we'll certainly be learning more and more about what the final decision says, and then grappling with enormous potential consequences of the decision as the years go on.
Well, this has been a very enlightening conversation. Thank you so much for coming on and sharing your expertise.
Thank
For
you.
having us.
Lisa Ikemoto and Courtney Jocelyn are Martin Luther King Jr. professors of law at UC Davis. On the next UC Davis Live, as we head back into wildfire season, we'll take a look at advances in forest management in preventing wildfires. That's coming up Thursday, May 26th at 1 p.m. Pacific. Until next time, I'm Satirius Johnson, and this is UC Davis Live.